My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
Welcome to class. We are still looking at course 11, which is speeding up criminal justice process and human rights. And in this module, we'll be looking at the rights of victims and witnesses. Of course, how this relates to speeding up criminal justice process and human rights in Nigeria. Now, the lesson objective is to create awareness regarding the rights of victims and witnesses and the role of the Nigerian police in protecting these rights and how this impacts on criminal justice delivery process. What we are trying to say is that we want to create awareness. We want you to be aware of what the rights of victims and witnesses are and the role that you're supposed to play in protecting these rights as regards criminal justice delivery in Nigeria. At the end of this course, it is expected that you will increase your knowledge about the rights of victims and witnesses and how to protect these rights as a law enforcement officer. Now, the machinery for criminal justice administration in Nigeria principally has three principal pillars that it is standing on. The first pillar is the criminal law, the second pillar is the criminal procedure, and the third pillar is the law of evidence. While the criminal law lays down the basic rights of citizens and corresponding obligation within the society, the criminal procedure and law of evidence seeks to provide machineries for the enforcement of the rights and duties as laid down by the various rules of criminal law. The victim is shouldered with the task of playing a distinctively secondary role. You are the one that is going to play the primary role of what law enforcement and investigating those allegations when it is brought to your notice. The victim's role distinctively is only to report he's only to report a crime. That is what the law says. The victim's own responsibility is to report the crime, while the police is required to treat the accused person as innocent until proven guilty beyond all reasonable doubt by a court of competent jurisdiction. And this is very important. An accused person remains innocent until the court says otherwise. Now, the victim is completely at the merciful discretion of the law enforcement agents. A victim is at your mercy. A victim is looking up to you to help him or her access justice, and this is really very important. In cases where the police decide not to effect an arrest and prosecute, or even allow the offender to enter into a plea bargain, the victim's right to legal recourse are limited. And this is really very important. If you refuse to do your duty as a law enforcement officer, it means that the victim, his right to access justice will now become limited. Now, victims are required by law to serve as principal witnesses in courts. That's, of course, one of their primary duties. For them to access justice, they need to come before the law court to come and give witnesses or confessions regarding the violations that they experience. The victim is often told that crime is an offense against the state, and therefore it is the business of the state to prosecute the offender on behalf of the victim. Of course, when someone commits a crime, it is not just a crime against the victim, it is also a crime against the state. And the states have the responsibility to prosecute the offender on behalf of the victim. And when the state fails in this duty, it means that the victim is now being denied the opportunity to get justice, and this shouldn't be so. We're going to look at who a victim is. A victim is a person or persons who individually or collectively have suffered harm, including physical, mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omissions that are in violation of the criminal abuse of power. You need to note this. A victim is someone who has suffered harm. The harm may be physical, the harm may be mental, the harm may even be emotional or economic. It may have to do with business dealings, and someone was ripped off at the end of the day out of a business dealing that has any form of substantial impairment on his or her fundamental rights through acts of omissions that are in violation of criminal abuse of power. This can be found in Article 1 of the United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. Now, victims of crime and other people who have knowledge about the commission of a crime are often required to testify at a trial or at any other court proceedings. Now, victims of crime or people who are probably there when the crime was committed or witnesses to crime, these classes of people are expected to come and testify during a trial or court proceedings. Crime victims and witnesses might experience feelings of confusion, frustration, fear, or danger. Imagine when someone is a witness to a violent crime. What do you think that crime will have on the person's psyche? The person may be confused, the person may be frustrated, the person may even be fearful, the person may be in fright. And that is why we advise in the earlier modules that while dealing with victims, it is always very important to treat them with some respect and dignity so that you put them at ease, that they will be able to help you to be able to build up your case before you go for trial. Justice for victims of crime is synonymous with the theory of justice prescriptions. Now we are going to look at certain definitions. We're going to look at, now the first one we're going to look at is when we say a punitive measure. Punitive measure, what do we mean? When we say a punishment is punitive. Punitive is to punish the offender for criminal conduct. So when we say we are giving punitive sanction, it means we want to punish the offender. Now, deterrence means to deter other members of the society from committing such offenses. Now, we also talked about, I remember I mentioned something about preventive and corrective action. Now, deterrence is a form of preventive action to deter other members of society from committing such offenses. Rehabilitation of offenders after a period of incarceration to integrate them back into society is also very important. Remember that we said earlier that the reason for justice most times is not just to punish offenders, it is also to rehabilitate offenders and to ensure that those kind of crimes are not committed again. We're going to look at reparation and retribution. Reparation is to put the victim of crimes back to the position he was before the crime was committed. It means that maybe someone was violated, or maybe the rights of someone was taken away, or maybe something that belongs to someone was forcibly taken away from him. Reparation means to return back to the person what was taken from him, or to return the person back to his original position before the crime was committed. Retribution is to punish the criminal with the same punishment to ensure that he reaps what he sows, to deprive others of liberty, take away their life or take away their properties. So retribution means when you want to punish an offender, you punish him with the same measure with which he measured to someone else. And this is also very important. Now we're going to look at the different types of crime. Here we'll be looking at two types of victims of crime as follows. Number one is the direct victim, who is the direct person who bears the violation or the pain of the crime that was committed, while we have also the indirect victim. In terms of the direct victim, this refers to persons immediately victimized. Those people who were primarily victimized are called the direct victims of crime. For example, if Audu slaps Abubakar, or injures him, or robs him, or steals his property, or breaks into his home at night, Audu is the active offender, while Abubakar is the direct victim of Audu's criminal conduct. What we are trying to say is that maybe Audu robbed Abubakar or injured him. Abubakar is the direct victim because it is him that is carrying the injury. It is his property that was stolen. Okay, so that makes him the direct victim. Now, in terms of indirect crime victim, this is a person or persons other than the direct victim who suffers some form of loss or pain as a result of the crime. We are talking about people who are around Abubakar, who also suffered not directly but indirectly because of the crime that Audu committed. For instance, if Audu stole money from Abubakar, the children of Abubakar are indirect crime victims. Why? Because the money that the father probably would have used to provide their basic needs in life, the money is no longer there, and the children are now suffering because Audu stole from Abubakar. So this is a person other than the direct victim who suffers some loss or pain as a result of a crime. In the hypothetical situation above, the relatives of Abubakar, like I just said, are the indirect victims of the crime that Audu committed. And this is also important for us to note down. The obligations of victims of crime. We're now going to look at the victims of crime. According to law, what are they supposed to do? What is expected of victims of crime? Now, the obligations expected of victims of crime are threefold. Number one is to report the crime to the police. Number two is to assist the police in carrying out their investigation. Number three is to assist the court in prosecuting offender by providing witness testimony against accused person. So we are trying to say that there are three different obligations that a victim of a crime needs to, you understand, carry out. The first one is to report to you, the police officer. The second one is to help you in your investigation. The third one is also to help during prosecution in court by coming to present witness to be able to buttress the allegations that he is bringing against a particular offender. Now, recommended measures to be taken at the international and regional levels for victims of crime. Beyond just what we do at the national level, there are also some principles or some provisions that have been made by international and at the international and regional levels to also help victims of crime. At the 7th United Nations Congress on the prevention of crime and the treatment of offenders held in Milan, Italy in 1985. The Congress addressed the rights of victims of crime and abuse of power and unanimously adopted the resolution. Of course, you can see that the resolution, which is called the Declaration of Basic Principles of Justice for Victims of Crimes and Abuse of Powers. The declaration recommended measures to be taken at the international and regional levels to improve access to justice and fair treatment, restitution, compensation, reparation, and social assistance for victims of crimes. So according to this particular convention, which came into effect in Milan, Italy, they made some provision that also helped victims of crime to get restitution, to get compensation and reparation for the crimes committed against them. And we are also still going to look at this in details. Victims should be treated with compassion and respect for their dignity and are entitled to prompt redress from harm caused. And this is according to the Milan Declaration. Judicial administrative mechanisms should be established and strengthened to enable victims to obtain redress. Victims should be informed of their role and the timing and the progress of the cases. And of course, we said this also. When a victim comes to lay a complaint to the Nigerian police, you also have a duty to update the victim from time to time. Okay, we are still investigating. The case hasn't proceeded to court, but we are still trying to gather our evidence. When we have finished, we will take the person to court. The essence of doing this is because if the victim doesn't know that you are still on the case, the victim may now lose hope and faith in the ability of security agents to protect his or her rights. The views and concerns of victims should be presented and considered at appropriate stages of the process. If a victim, for instance, is not very happy with the pace the case is progressing, that victim reserves the right to complain to you, and of course you need to look at the merits of the person's complaints. Steps should be taken to minimize delay and inconveniences to victims, ensure their privacy, and protect them from intimidation and retaliation. And this is really very important. When a victim comes to complain to law enforcement officers, it is important to protect them from harassment or from retaliation. If they come to complain, and because they came to complain, they are now being intimidated, they are now being witch hunted, it means people will now be afraid of coming to the police with their complaints. Offenders should, where appropriate, make restitution to victims or their families or dependents. What we're trying to say is that as much as possible, those who have offended victims should try to do some form of restitution or reparation to victims of their crimes. And this is also very, very important. When compensation is not fully available from the offender, states should provide compensation to victims or their families in case of significant physical or mental injury. What we are trying to say here is, if, for instance, maybe the offender is not able, maybe because of his economic status, to be able to carry out this restitution, the state should be able to do this on behalf of the offender if the loss is significant or if the loss caused significant physical or mental injury. And this is also important. Victims should receive the necessary material, medical, psychological, and social assistance through governmental and voluntary means. You understand? Government can help, and also private and non-governmental organizations can also help. States should consider incorporating into national law norms proscribing abuses of power, including political and economic powers. They should also provide remedies to victims of such abuses, including restitution and compensation. And we've already looked at that. So we move forward to the next slide. Who is a witness? What is the definition of a witness? We are going to define it very shortly. A witness may be defined as a person who is called upon to give evidence in a criminal case, or a person who witnessed the commission of a crime. When someone is present at the crime scene, when the crime is being committed, the person is a witness. If someone is brought to court to come and give evidence in a criminal proceeding or even in a civil matter, you know that the person was a witness to, the person is also regarded to as a witness. Some witnesses are classified as vulnerable. This includes children, victims of sexual offenses, mentally ill persons, elderly persons, or any other person who may have suffered emotional, traumatic, or physical injury during the commission of a crime. These classes of people are called the vulnerable witness. Now, for instance, maybe a child was present when a crime is being committed. That child is a vulnerable victim, or someone who is physically impaired or mentally impaired, or an elderly person. Those classes of people are regarded to as vulnerable witnesses. Investigators and prosecutors cannot do their work without the participation of witnesses. That is why ensuring that they appear in court is very important, because it becomes very difficult for you to carry out your assignment if there is no witness to actually help you in prosecuting that case. If you are required to testify as a witness in a trial or other proceedings, you will receive a subpoena telling you when and where to go to court. A subpoena is the letter that is given to witnesses to come and give some form of testimony in court. A subpoena is a formal court order telling you to appear in court, and there are serious penalties for disobeying a subpoena. If you are called to come and give a witness in court and you've been subpoenaed, it is wrong for you to deny going to court, and you can be held in contempt of the court if you refuse to appear. If you know in advance of anything that may keep you from attending a required court appearance, let the court or counsel know immediately so that an attempt may be made to adjust the timing to suit you. Now, we are all going to look at witness protection, because we said that there are some classes of witnesses are vulnerable. So we need to take extra care to protect not just this class of witnesses, but also other witnesses who may be in harm as a result of coming to court to come and give a witness. There is no law protecting the right of witnesses in Nigeria, and this is really an aberration. Okay? In some developed climes, there is a law protecting the witnesses from harm. Oftentimes, the vulnerability of the potential witness to attacks, intimidation, and other abuses dissuade persons from opting to provide the needed witness evidence. You know, when someone is not adequately protected, when probably the case is a very serious case, and the person has been harassed, or the person has been intimidated, or the person has even been threatened, the person may be afraid to come to court to come and give evidence. Even those that have appeared as witness in a court to testify against those involved in criminal acts are often attacked, intimidated, or even harassed, by the people involved in these crimes. The Witness Protection Bill is still before the National Assembly, and we are advocating for a speedy passage of that bill because it is really very important. Efforts are being made through the Office of the Honorable Attorney General of the Federation and Minister of Justice to ensure the passage of the bill and the incorporation of the bill, into the Criminal Justice Bill. It is recommended that the collective efforts of stakeholders should be geared towards ensuring the swift passage of this very important bill. Now we're going to look at non-attendance of witnesses as a reason for delay in criminal justice process. Remember that what we are looking at in this particular course is how we can speed up the criminal justice process so that justice can be delivered swiftly and in time. A significant cause of delay in the criminal justice process is non-attendance of witnesses in court. Maybe a case has been set for a particular day and the witnesses are not there. It can delay, of course, the case. This includes ordinary citizens, including victims, specialists, witnesses such as investigating police officers, IPOs, and expert witnesses, for example, medical doctors or coroners. Witnesses play a vital role in criminal justice delivery. This is why the attendance of witnesses in court is very, very important. Prosecutors and investigators in various criminal justice institutions are constantly faced with the challenge of trying to track down the key witnesses. And of course, this is very important. Maybe you're investigating a case and you have a witness who used to live in number 5 so street. And then maybe 3 months down the line, you go to get the witness to come and appear in court. The witness has changed location. That becomes a problem. And of course, that can also cause unnecessary delays to cases. We are also going to look at more reasons why maybe witnesses refuse to attend court proceedings. Why is it that sometimes a witness has given you his word, okay, I'm going to appear in court today, and maybe you now go to court and the witness is nowhere to be found? What are the reasons that can maybe cause their non-attendance in court? absence of structured mechanisms for recording and keeping up to date information on witnesses' whereabouts. Like what I just said earlier, you need to be able to track the witness, know whether the witness is still living where he told you he was living when you were investigating the case, know if the victim, if the witness is even disposed to attend the court proceeding on a given date. All of these things are things you need to find out in order to ensure that they attend, the court proceedings. Number 2 is incorrect or complete contact details for witness. When we are filling in the contact details of witnesses, it is really very important. You get their phone number, you get their house address, you get even their, their office address, so that probably when you go to the house and you don't find them, you can also equally go to their offices to be able to look for them. In continuing, the non-existence of financial aid to enable them cover reasonable expenses which they incur in the process of coming to court. Now, you have a witness who is supposed to come and testify in court. If the witness doesn't have the economic means to be able to pay his way to come to court, the witness can decide to stay at home. So it is important also to give witnesses some form of financial aid to assist them and support, some of the expenses they incur as a result of coming to court to come and testify. Fourth one is the fear of intimidation and harm from suspects or suspects' families or even their contacts. We said that earlier. And we said that victims sometimes are exposed to threat, to harassment, to even bodily harm or even mental torture. So it is very, very important that victims are given some form of protection so that they will be free from fear of intimidation. Another one is social stigmatization of victims of certain crimes, especially in relation to victims of gender and child offenses like rape, unlawful carnal knowledge, domestic violence, or child defilement. Now, you realize also, and I really want to stress this point, you realize also that in some cases, when a girl is involved, is a victim of rape, it is difficult for them to come out to come and complain. Why? Because of societal stigmatization. Because they are stigmatized, people will say, this girl was raped. And the girl is thinking, if I come out now, what happens to my reputation? How will people now look at me? Because of that, the girl, instead of coming to seek justice, will now keep quiet. And the danger of doing that is that now the people who are supposed, the offenders who are supposed to suffer for their crime, are now emboldened to continue to perpetrate such crimes because they were not brought to justice. Another one we're going to look at is the lack of understanding of citizens of their legal obligations in relation to witness duties in trial process. Now, citizens are obligated by law to help in criminal proceedings, to come and present, their own side of the story if they are really witnesses or accessories to crime. And this is very important. So we need to make citizens aware of their duties and obligations according to law to assist in cases that are before the court. Another one we are going to look at also is witnesses that fear that they may be harmed or intimidated by suspects or their families. We've looked at that earlier. The social stigma attached to victims of certain crime. We've looked at that also when we talked about rape. The unreliability of systems to enforce witness attendance requirements through use of witness summons. When a victim has refused to come, what do? You need to talk to the victim, or even issue out a summon to the victim. The victim must be made to come and must be made to understand that the evidence is coming to give in court is really very important and that the person should attend. Another one is age of victims. Maybe the age of witness, rather. Maybe the witness is still a child. Maybe the witness is underage. You need to also take that into consideration. Before you can bring the witness to court, you need to talk to the witnesses' parents or guardian or someone who is looking after the witness to be able to obtain permission before the witness can be brought. Another one also is that many citizens have lost faith in the criminal justice system and believe that it will be a waste of time to give testimony in court. Because of the way we've handled cases in the past, some people now say, there is no need of coming to court. Whether I come or not, the person will be left off the hook. And because of the loss of faith in the system, many witnesses refuse to come and give testimonies. Many persons are nervous about criminal justice institutions. They are saying, if I come, what will happen? If I come to court to come and give a witness, will I not be arrested? So because of that fear, some people decide to stay away. It's also possible, that the star witness may have died or the star witness is dead, and that's one way too that one thing that also causes delay, when it comes to witnesses coming to court. Another one is overt collusion between witness and the accused person. It's possible that the witness has gone to collude with the person who committed the crime to say, don't come and give witness against me. Another one is that the first point of contact with criminal justice for a witness is usually the investigating officer. If the investigating officer doesn't do his work very well, it is possible that the witness may not want to come to court. So the witness should be briefed on the following matters at the time of the first meeting. These things we are going to list out here, you must tell the witness. The witness has to know before you go on, so that the witness will know what he or she is getting into. Number one, the possibility that they may be required to come and answer questions from time to time, that they will be contacted from time to time, as the case goes on, that their details has to be taken down in order, for follow-up. Now we are going to look at situations where you refer witnesses or vulnerable victims to other available services. For instance, maybe you referred a witness to go and see a psychologist or a psychiatrist, depending on what the needs of the witness is. How is this supposed to go? Now, it is important that investigators and prosecutors like yourself, who is watching me, keep a record of agencies, providing care and support to vulnerable victims or witnesses. You have the same tracking record you have for the witnesses. You also need to have a tracking record that documents other agencies or organizations that are providing special care and support to vulnerable victims or witnesses. Vulnerable witnesses such as witnesses of rape, human trafficking, children, it is really important that they access some form of help in order to prepare them psychologically and otherwise to be able to help you in your investigation. So witnesses such as victims of rape, human trafficking, children, etc., should be referred to or informed of organizations where they can access expert or professional help, as this will help ensure that they are psychologically and physically ready and willing to testify when required. It is really very important. You have a witness, you need to prepare that witness psychologically. If what it needs to prepare a witness psychologically is to see an expert, then it is really very important that the witness sees an expert. You know why it is important? It is important because in court, if the witness is not very prepared, if the witness goes to court and doesn't perform very well, it could jeopardize your case. So this is really very important. Many such witnesses are not willing to testify due to psychological trauma they experienced as a result of the crime. And this is why we are asking for some form of professional help. So government agencies and non-governmental organizations which provide such specific care to individuals can play a huge role in this regard. And of course, this is very, very important. Now we're going to look at the security of a witness. How do you secure and safeguard the life of your witness? How do you ensure that harm doesn't come to the person who is supposed to be a witness in court? Now, the safety and well-being of the witness is a high priority. It is very, very important that witnesses know that it is a criminal offense for anyone to try to threaten a witness before, during, or after a trial. You need to let them understand that it is a criminal offense for them to be threatened by anyone simply because they have opted to give a testimony in court. They need to know this so that if such a thing happens, they know who to come and complain to. It is a responsibility of the investigating police officer, the IPO, in charge of the case to provide the witness with reasonable protection from harm during the course of the investigation and even during trial. So as an IPO, you that is watching me now, if you have a particular case and you have a witness, it is your responsibility to provide some reasonable protection for the witness, protection from harm, whether it is physical harm or even psychological or mental harm in some cases. So it is important that you protect your witness such that harm doesn't come to your witness, because if harm comes to your witness, it's possible the witness may decide to opt out, and at the end of the day, it will now jeopardize your case. It is important that witnesses' legitimate security concerns are addressed. If they bring any case to your notice, case bordering on any form of harassment from any quarters, it is important that you take it very, very seriously. Even where the decision to prosecute has been made and the case has been charged to court, the investigating officer is encouraged to work together with the prosecutor to ensure that adequate protection is provided to the witness. And this is also very important. Prosecutors should, as much as possible, seek to ensure that witnesses who may need protection against intimidation are afforded protection by ensuring that such threats are reported to the police and to the courts. And this is really very important. Now we're going to look at confidentiality. Confidentiality of the witness. If a witness has come forward to help you with your case, how do you keep the person's identity confidential? Because the person, making the person's identity to become public means you may even be jeopardizing the person's interest. So information about witnesses must be kept confidential. Witnesses' personal details, for instance, their house address, their phone number, their office address, must be kept secure and in no circumstances disclosed except as required in a court of law. Details about witnesses' identity must never be passed to the media or any other authorized person. And this is really very, very important while dealing with witnesses. We have come to the end of this particular module, which is module 4 in course 11. I believe that we've had fun, going through some of these things as regards witnesses and how to deal with them in the course of our investigation. In our next class, we shall be dealing more on what we can do to speed up the criminal justice procedure in Nigeria. Thank you very much.